All right, let's get started. I'd like to welcome you to today's webinar on the Best Practices Affirmation Program. My name is Mary Malguar. I am a board member of the Institute for the Fiduciary Standard. I'd like to welcome everybody today. Before we get started, I would like to mention a couple of housekeeping items. The first is that I think we expect comments to go for about 20 minutes today, and then we'll open up the session to a question and answer period. Everyone will be muted except for the speakers until we start the Q&A period. Then I'll unmute everyone and we can take some questions. The second item is we'll be recording the session today, so we look forward to your questions. We will be posting the recording at the Institute's website, which is on the cover page here. We encourage you to share this webinar with colleagues that you would like to introduce to the Best Practice Affirmation Program. And please contact Knut if you have any further questions that are not answered on today's call. So with that, I will turn over the session to Knut Rostad.
Thank you, Mary. Where'd my screen go there? And welcome everyone to the webinar. I'm going to provide an overview of the practices and the program, and provide a brief update on terms of where we are today. And then Dan Moysen of Moysen Fitzgerald Tamayo, one of the first firms in the country to subscribe to the best practices, will discuss why he has done so. And then Brian Hamburger, CEO of Market Counsel and General Counsel to the Best Practices Board, will address some regulatory issues. Okay, next slide, please. All right, and then the next slide.
Thank you. Sorry.
No, I'm sorry. To start, just as a highlighted overview, I think it's important to make three general observations about the best practices. They are crafted to reflect true fiduciary duties as set out in the 40 Act, common law, and if applicable, ERISA. That's the first point. The second point is that best practices emphasize advisor conduct around fiduciary duty of loyalty, and that revolves around conflicts of interest, transparency, and plain language and clear communications. That's the focus of the practices. And then finally, sort of the third point is that they aim to be written such to be concrete, verifiable, and understandable language in order to assist investors in screening and evaluating advisors. And this is an important characteristic, we think, of the best practices. So what I'm going to do right here is I'm going to, over the next three slides, slide 4, 5, and 6, I've highlighted each of the best practices, but to put them out there. But I'm going to make a few comments about 3 or 4 of them, those that basically have received the most questions and comments over time. So, for example, here on slide 4, practice number 4 requires that the advisor provide a statement of investment fees and expenses, and explicitly describes that this can be done in the context of a good faith estimate of the fees and anticipated expenses at the outset of the engagement, and then thereafter, on request for the advisor to do the same in terms of the preceding year's performance and expenses and fees. So I think it's important to point out explicitly what that practice requires and what it does not require. Then to move on to the next slide, slide number 5, the practice 7. Practice 7 addresses the issue of dealing with compensation based on a transaction involving commissions and or third-party payments, and what is required to overcome that conflicted recommendation. This practice requires that there be significant prudence and care in making and mitigating a conflicted recommendation, such as to ensure that the burden inherent in not avoiding a conflict is absolutely overcome. And I think when you look at the steps that are required to go through in terms of to fulfill the practice, it is a rigorous process, and at the end of the day, it's requiring that the transaction, that the recommendation, and the commissions and third-party payments involved must not only be reasonable, which is a baseline requirement, but also be fully transparent and level. So that I think highlights the practice 7. Now going on to the next slide, slide 6. A quick comment about practice 11, controlling expenses and considering peer group expense rankings. The point is that what is required is to have procedures for being able to determine what are reasonable expenses, and it's not required in the practices to, at this point, to consider peer group rankings or in terms of expenses. So that's, I think, an important delineation to make. And then finally, on the last practice, practice 12, which calls for the firm affirming that the broker or advisor can meet the practices. This is a very specific context. The practices allow for individual investment advisors or brokers to try to get through the screens and meet the practices. But this practice here explicitly calls for the firm being able to affirm that the individual broker or advisor can, in fact, meet the practices. So I think that is another important point to make. Going on to the next slide, I think in terms of standing back and looking at the best practices sort of in their entirety, I think it's important to recognize what comes through, and I think there are 3 or 4 points that I think are deserving of sort of underscoring here. And the first one is that the best practices raise the bar for advisors and therefore investor protection. The simple fact is that we believe that here advisors are required to do more, and to the point where industry pundit Bob Clark has concluded that the best practices affirmation program is, quote, the highest highest fiduciary standards in the industry. So I think that's first and foremost, raising the bar on advisors and investor protections. The second point, it gets to, again, how they are crafted, and crafted in plain language, and how that can help advisors show investors, notwithstanding the legal language that is so often used, that when you break them down to their essence and look at what fiduciary duties require, that it comes down to common sense, the common sense in fiduciary duties, that align interests between an advisor and their clients, and further instill trust and confidence. I think that's the second important point. And then third, this common sense approach that we believe we've taken also helps investors differentiate advice from sales, and therefore helps investors screen for advisors who best fit their needs. So I think those are three overriding takeaways that we believe are important. And then finally, and then on my last slide here, I think it's important to note that there's wide support across the RIA community for the best practices. We have TD Ameritrade Institutional and Pershing advisors expressing their support for them, among others. And then former SEC Commissioner Luis Aguilar, the third longest serving commissioner in SEC history, has also expressed his support. In addition, we have other well-known individuals who have spoken out on the benefit of the practices and the program. So that's the first point. The second point is, and this is on our website, but I wanted to underscore, the first group of subscribing firms will be announced in March. I don't know precisely when in March, but we will make that announcement in March. And it seems certain that these firms will all be RIA firms. It's noteworthy, we believe, that since best practices were finalized in September 2015, and then also since the Affirmation program was announced in September 2016, that we have not gotten an inquiry from a single broker-dealer as to the best practices or the Affirmation program. So this is, I think this is noteworthy in the scheme of things. Then finally, I should say that in light of the questions that we have received over the last 3 or 4 months, and perhaps in light of the questions that we received today, we are preparing some additional guidance for advisors in terms of meeting the best practices that will come out in middle February. So I think that's noteworthy as well. So on that note, I want to thank you and turn the mic over, so to speak, to Dan, and let him continue with his remarks.
Thanks, Knut. Yeah. So you wanted me to talk a little bit about why we went ahead and subscribed to these practices.
Correct.
You know, there's a certain mission that a lot of people in our field feel called to, because there's so much confusion among the public, and you know, you want to help as many people as you can, but it's extraordinarily confusing to consumers to figure out who's going to act in their best interest and who isn't. When I get asked for referrals to advisors in other parts of the country, if they're not members of certain organizations, sometimes it's very difficult for me to find names of people that I would have some level of confidence in. When I'm told by somebody that's oh, do you know so-and-so, he's a financial advisor, I can't tell you what the person does for a living. The CFA, I think, just recently came out with a study about use of titles and all the usual financial advisor stuff and the hat switching and all the things that have aggravated a lot of professionals in this field for a long time. So when these these best practices came out, we looked at them and we thought, you know, that stuff we already do. We're already acting as fiduciaries. We don't take that fiduciary hat off when we get into areas where we're not experts. We refer out like you're supposed to. We're already assessing costs when new clients come in and showing clients what it will cost to work with us, because almost all the time it works out to be a wash or favorable. So that's an easy comparison to make. We're already putting advice in writing. We're already making investment recommendations within the context of a financial plan, so it's pretty easy to come up with a reasonable basis for recommendations. We don't do principal trading, all of those types of things. So when these practices come out, and there's some specificity in here, reasonable basis for recommendations and best faith cost estimates and all these kind of, and benchmarking, we're always looking to see if what we're using is the best we can find, or if anything new has come along that we need to be looking at. And so we're always comparing to what's out there in the marketplace. We just want to make sure, you know, we're within reason. So we're figure from a consumer standpoint, when everybody, if the DOL rule sticks around in some form or fashion, is going to say they're a fiduciary, meaning in their minds a lot of them are part-time. We want to give people a pretty easy to understand tool to understand who's really keeping their interest at the forefront all the time. And by making public affirmations of these practices and doing so in writing, and that phrase "in writing" is in here a number of times, it really, I think, can help consumers cut through the bull. So I think it's good for the consumers. I think it's good for us as practitioners. And from our firm's perspective, it was pretty easy to say, yeah, we do all these things because we were already doing most of them.
Thank you, Dan.
Mm-hmm.
Brian, could you take the baton?
Happy to do it, Knut. Happy to do it. My name is Brian Hamburger, and I am the president and CEO of Market Council, but more relevant here, have had the pleasure of serving as general counsel to the Best Practices Board. When Knut first approached me about best practices, there may have been a bit of an eye roll in terms of, well, you know, here we go again in terms of trying to clear up the confusion that simply runs rampant throughout our industry. And I think Dan hit the nail right on the head in terms of what we perceive to be the top utility of these best practices. And really, it's consumer driven. It's trying to identify for consumers or would-be investors, trying to identify the features that would separate the wheat from the chaff. It's not picking favorites. It's not saying that advisors are better than brokers or brokers are better than advisors, but rather it's simply saying that those financial professionals that are willing to commit in writing to act in your best interests are standouts, and they should be recognized for such, because if you're going to someone for advice, well, you want to make sure that that advice is relatively free from conflicts, and to the extent it's not, that those conflicts are properly disclosed. And so we set about a very arduous task over the preceding year plus to really try to identify what features are worthy of simply documenting in terms of practices. So what are the best advisors actually doing, and where it may be important to raise the bar. And while Knut indicates that that this does indeed raise the bar, I would also temper that with, it doesn't raise the bar significantly. It really just identifies what the best firms are already doing or are already within striking distance of doing. And certainly as we speak to clients and prospective clients, it's the type of practices that they want their financial advisor to be doing. So with that, I'm happy to answer any questions specifically with regards to risk mitigation, regulatory compliance, and similar issues that these best practices were all designed to help address.
Thank you, Brian. Now we can open the floor to questions, and so just speak out and direct your question to all three of us, or to one of us, or however you see fit. So the floor is open.
Canute, this is Marjorie Fox of FJY Financial, and as Mary knows, I ran all of your wonderful materials, and I'm a great fan of this, by our compliance firm, Stark & Stark. And Stark & Stark raised some questions. The first one, probably the most important of the questions, was the lack of definitions in these best practices. Terms like reasonable basis, best interest, and material conflicts are not defined. And what that possibly can lead to is a between a client and an advisor. So I guess I'm asking, will you all define these terms to avoid confusion and ambiguity?
So this is Brian Hamburger. I'm sorry, I didn't catch your first name.
It's Marjorie Fox of FJY
Marjorie.
Financial.
Okay.
Yes.
Thank you, Marjorie. Marjorie, thank you for your question. The short answer, and of course I'm a lawyer, so I can't just leave you with the short answer, but the short answer is no. The short answer is that the Best Practices Board does not have any current plans to identify with specificity those terms. And the reason the terms you mentioned are things like reasonable basis, best interest, material conflicts. The reason for that is that, number one, there is substantial case law, including enforcement actions and no action letters, that already define the expectations for the advisor. It's already very clear what indeed, for example, a material conflict is. Reasonable basis is already something that's very well defined within case law. And what we didn't want to do is provide any type of redundancy and potentially conflicting information here. These are deemed to be, best practices, what the best firms are out there doing subjectively, based upon what we think is indeed best. The other thing is we wanted to that came back were commenters from, for example, NAPFA. There were commenters from folks that were running what we would call politely a hybrid practice, right, a fee and commission practice. And we wanted to maintain an open architecture to allow various business models and not pre-select one business model over the other. And so when you talk about things like a reasonable basis, that differs. It differs based upon the type of business you're running and the expectations that you're setting forth with your client. All that said, there is an overriding concern that what we didn't want to do is allow the best practices to create a liability overhead on firms. And so by specifying what indeed these terms meant, potentially to the detriment or conflict of what's already out there, we would be in a position where we would actually be adding the risk burden left to be defined the way they would ordinarily be defined, but nothing within those terms raises the bar with respect to liability that would otherwise exist.
Well, thank you, Brian. I too am I'm a recovering attorney,
Sorry to
not
hear
a
that.
practicing one. I know, but I've recovered.
Well on your way.
But I mean, my point is that that FJY Financial, and I can't believe we'd be the only firm. We don't want to go against our compliance counsel, and Stark & Stark isn't the only well-known compliance counsel, but I have to believe that you would want to address concerns raised by firms like Stark & Stark to advisors like us at FJY Financial. Or you're not going to get us, I'm not going to push this further, and I pushed it already. I'm not going to push this if Stark & Stark says don't do it because terms are undefined, and they have other concerns that Mary may have forwarded to you. Really, I think it's in your best interest, if not to define these terms, to point to the definitions in case law or otherwise that already exist about reasonable basis and otherwise, or you're going to lose some of the very firms I would think you would want to be a part of this.
Sure. And I can understand your perspective, and you know, I'm not practices board, Marjorie. I can only speak from my perspective in terms of giving advice to the board with respect to both legal matters and regulatory compliance matters. And you know, we would, if we were to write any type of clarifying language and provide links to the terms that you had mentioned, we would effectively be writing a thesis. We'd be writing a what's referred to as a blue book, right, on regulatory compliance under the Advisors Act of 1940. And so I think, you know, this is not intended to tell firms, you know, what a reasonable basis is of fiduciary law to identify what indeed is in the client's best interest. That's not the intent of these best practices at all. This is merely intended to port over those existing obligations and ensure that we can link them to practices that the very best firms are doing in order to primarily document and evidence to their clients what indeed they're doing to achieve those expectations.
Yeah, Marjorie, I can add one little twist to this discussion. We also use Stark & Stark, and the response that we got was, as long as you're doing what you say you're doing, you really shouldn't have a problem.
Okay, well, we'll have to talk to Stark & Stark.
You know, Margie, I would just like to add, and I'm not going to add anything more on the legal point of view in terms of what Brian said, but I guess I wonder whether there's some just simple confusion regarding the concern expressed here, given that as Brian pointed out, that these terms are dealt with extensively over the course of the history of the SEC, and that the other, of course, the other part of this is that by definition we're dealing with a standard based on principles, and you know, no one on this webinar needs to hear anything more in terms of what that means in terms of how we comply on a daily basis to what the SEC requires. And so I think that you know, that's just part of the reality, and we are we're aiming to reflect that reality, I guess, is one way of looking at it. So anyway, what was there any other questions, Marjorie, in terms of
let me
turn it over.
Yeah, let me suggest that we actually address this more thoroughly when we do prepare comments and move on to other questions that might be out there. Thank you, Marjorie.
Welcome.
Other questions out there?
Hi, this is Ben Tobias. Hi, guys. How are you? I love what you're doing.
Thank you, Ben.
Question for you. As far as the disclosure of fees up front, is that something that should go on to the IPS itself or on the wealth management agreement? Where does that go?
Brian, you want to take a?
Yeah, it's good to hear your voice, Ben. This is Brian. So you know, this actually goes exactly to the point that that Marjorie just raised. Is it goes where you think it's best to go, right? So certainly it could go if you have an engagement review process where you sit down and renew contracts with clients on an annual basis. Some firms do. Then by all means you can bring it into that engagement review process. If on the other hand you're utilizing investment policy statements and there is a fee component in there, then by all means you can certainly do it. If it's, you know, and some firms have a specific fee disclosure that they send out, but it's really, you know, it's really so long as that gets disclosed to clients, then it achieves best practices. How you go about doing that is really going to be dependent upon your firm.
Okay, great. Just as a side follow-up, as far as the calculation on investment fees and expenses, I am assuming that we should be using the specific client's portfolio as opposed to the firm as a whole.
Yeah, that's a great question. It is my assumption as well that we're utilizing, to the extent practical, the actual expenses that are going to be borne by that client. But there are some firms that have raised some interesting dilemmas with respect to how they can calculate for each individual client. But certainly, Ben, to the extent it's practical, then that's going to be the preference.
And obviously, it's an estimate in any case. It's not
That's right.
designed exact number. Okay.
That's correct.
Thanks a lot. Appreciate it, Brian.
Sure.
Other questions?
If no one else, this is Marjorie again, and I'll wait for other questions from others before I ask another question raised by Stark and Stark. So let me pause there.
Okay, thank you, Marjorie.
Okay, shall I go?
Yep.
Okay. The second of the three questions raised by Stark and Stark relates to number 9, best practices. And I'm reading the italics, but for advisors education, either a relevant postgraduate education or a specialized designation or certification requiring significant additional education. That's very vague. I mean, once upon a time, FJY essentially encouraged, really required a postgraduate education, JD, MBA, MFS, that kind of thing. And that's really no longer the case. And so what I'm wondering, looking at those of our staff who don't have the MBA or the MS or JD, what do you mean by specialized designation or certification requiring significant additional education?
Yeah, Marjorie, that's a great question, and I'm glad you raised it, because what we clearly intend to mean is that we're not talking about an educational institution master's degree or master's program per se, although that's fine. But the designations that are very common in the industry, of course, are absolutely intended to be included, starting with the CFP as perhaps being the most commonly held one in this space, along with the CFA charter holder and or the AICPA personal financial planning designation. So clearly, no ambiguity here. The intention was to broadly include certifications of that nature.
And just to answer Marjorie's question directly, Knut, I think that the way in which it's currently the language is drafted is it points, Marjorie, to someone having an undergraduate degree, right? So some type of typically a bachelor's degree, and either some postgraduate education or a designation or certification. So there is an education requirement and component here that the best practices certainly do point to.
I think it would be helpful if you could, give some indication of that, because again, and I'm a CFP and proud of it, but I wouldn't necessarily say it was a specialized designation, nor would I think of the CFP as a certification requiring significant additional education, given that our staff has their degree in financial planning, and what they did was then pass the exam and gain relevant experience. But you can see what I'm saying, that if I'm looking at that and saying, what does that mean, you might want to give a list that isn't all-inclusive of those things that satisfy this.
I can understand that that perspective. Understand that when we do publish a list, even if you say it's not all-inclusive, the moment that you leave anything off, you're going to get the question of, well, is or should that be included? And the Best Practices Board is not a governing body. It's not one that is vested with the authority to determine, what is and is not appropriate in terms of education. I will tell you that designations and licenses such as the CFP designation obviously did come up in discussion, and we did think that that they do require significant additional education. And I think that language appears there to get rid of any ambiguity that some of the certifications where you can certainly buy those certifications without any type of initial or ongoing education, that those really should be disregarded. And that was the intention there.
Thank you, Brian.
This is Ben Tobias again. I have a question on that. So we're going to have a registry of firms. Is there going to be anything done to make certain that the people who are in the registry are actually following the best practices?
For sure. Your creativity channeled in a different way, and an entrepreneur presumptively somebody that's got an economic...
I think someone's got to put their phone on mute. I'm not quite sure they're answering your question, Ben. But if you can hear me okay, I'll tell you
I can hear you. Yeah.
Okay, good. So the concept there is that we were not looking to create another governing body. We did not want to create another certification or review process that was going to be very expensive, thereby creating another barrier to entry. So firms that have achieved this best practices status are subscribing to it by way of notifying, obviously, the Institute that they indeed are subscribing to the best practices, and they would include language on their disclosure statement of Form ADV. That language would, in and of itself, set the bar as any other language on your Form ADV would, so that upon regulatory review, that would be the very clear standard that you were citing to, and regulators would certainly be able to look to that to see, what standard you indeed were pursuing. But there's no separate review or authority that the Best Practices Board would have over your firm.
I'm just
so essentially, there might be enough of that.
Essentially, we're using the SEC as a monitor, which I think is fine. I think that's good.
Yeah, that's accurate, and that and it was a purposeful decision to not create another layer of regulation and oversight upon firms.
Say that's an area that you've ever.
Can I just ask whoever is on the phone that they please mute their GoToMeeting?
Seriously, I mean, is it something you?
Okay, I figured out who it is. Thank you. I'll do that. Okay.
I would add,
Okay,
Ben, to that discussion, part of the requirements is that you put these best practices up on your website. So there's another mechanism for enforcement in that when you're making declarations to the public that you're doing something, you better be doing it or somebody can call you on it.
That's a good point.
So the Institute may not have any mechanism, but you know, I think, and Knut alluded to it a little earlier, there's been no interest from any broker-dealer firms, and that's probably a big reason why. They know they can't.
Good, two good points. Thank you.
Other questions? This is your time to let us know what you're thinking and what your concerns are and what your appreciations are. Any other questions? I guess I'll throw one out, Knut. How does the best practices, let's say, differ from an organization like NAPFA and what it's doing to communicate to the public what a fiduciary is?
That's a good question, and there are sort of two or three ways that I think about addressing that question. The first one will be the first one is the exposure that we will give to the registry of subscribing advisory firms throughout the industry as a way of furthering investor education. But in addition to that, we are in the planning stages of doing some programming from the Campaign for Investors website that from exclusively an investor's point of view really focuses in on the sorts of things that investors should be looking for in screening and vetting an advisor. And so broadly speaking, I think those two areas get to what you're asking. And the overlay of that from I think from our perspective is that our efforts to put the best practices in a language that notwithstanding the limitations and shortcomings we are familiar with seeing from many investors, that they can actually look at the core statement and understand what it is that they should expect from an advisor and the essence of it. And I think that's a huge contribution to what we're trying to do here.
Mary, I'm a longtime NAPFA member, NFPA, and actually the Society of Financial Service Professionals, that insurance group. And the main difference, one of the questions I asked originally when I saw these was, do we really need another set of standards? Is this really all that important? But one of the key differences is this lays out very specifically practices, things that are done to demonstrate the principle, primarily of loyalty, right? So I don't think NAPFA members would have any trouble meeting these standards. I'm sure they're all doing very similar stuff. It's just a matter of putting some things down in writing in spots where the clients can see them. Because fiduciary is a concept, and even fee only, they're confusing to people. And these have some very concrete things. You're going to get certain things in writing from advisors that are affirming that they're meeting these particular practices. So there was kind of a, this is something that people do when they're acting with undivided loyalty to their clients. And that had a lot of appeal to us because we thought it would resonate with the public.
Great, thanks, Dan. Other questions? And if not, we can wrap this up. Other comments?
You know, Mary, this is Brian Hamburger. I just want to, I want to point out that underline, if I can, what Dan just said. And you know, as we sat around the table, often by telephone, other board members were instrumental in moving this forward. This is what the best advisors do to evidence their fiduciary duty. It is not the only way to achieve fiduciary status. It's not the only way to act in your client's best interest. And it's not out there writing new case law or providing another layer of oversight or enforcement. So this is a very specifically designed tool, a very practical one at that, that differentiates itself merely with the clarity and restraint. It's as important to really understand what these best practices do not do as it is to understand what they actually do. And I appreciate, you know, Dan, leave it to an experienced practitioner to cut right through what it actually is. So, so thank you for that.
Well, thank you, Brian. And if there are no more comments, it looks like that there are not, unless Marjorie has one more question. If she's still on the phone, I don't know, or on the call from her perspective, but we'd be welcome to answering that. But if not, I want to thank Brian and Dan for joining us and providing their input and their expertise. And thank you, Mary, for administering the call. And I encourage those with any additional questions to email me or contact me by phone with them as you see fit. So thank you all very much, and on that, I guess we will close.
Thank you, and we'll have the recording on the website probably tomorrow or the day after. Thank you.
All right.
Thank you.
Bye-bye.